Hello, everyone, and welcome to the OUP webinar series. My name is Kirsten Loita, and I head up University Relations team here at Osage University Partners. Today, we are having a conversation on licensing practices to non-U.S. startups. The webinar will cover common startup licensing issues and concerns across 3 different geographic regions: China, the UK, and Israel. A panelist of experts who have worked in these regions will discuss particular variances in license clauses and startup structures that U.S. tech transfer offices may encounter when licensing to entities incorporated in these countries. Lastly, our panelists will share best practices for universities struggling to license a startup abroad. To get started, I'd like to introduce you to our speakers. Terry Willey is Executive Director of Indiana University Ventures and Fund Manager of the IU Philanthropic Venture Fund. Terry previously served as Founding Chief Executive of Cambridge Enterprise, the technology commercialization affiliate of the University of Cambridge in the UK. Welcome, Terry.
Thank you.
All right, next we have David Ai, who is the retired director of the Office of Innovation and Commercialization, as well as Chief Innovation Officer of the University of Hawaii System. David came to the University of Hawaii from the City University of Hong Kong, where he served as Director of Knowledge Transfer, leading the university's IP commercialization operations for 3.5 years. Welcome, David.
Thank you.
And Amir Nyberg serves as Associate Vice Chancellor and President and CEO of UCLA Technology Development Corporation. Prior to joining, Mr. Nyberg served as CEO of Yeda Research and Development Company in Israel, the tech transfer company of the Weizmann Institute of Science. Welcome, Amir.
Thank you very much.
Great to have you all here. While we get started here for our audience, in just a moment, you'll notice a poll appearing on your screen. If you could please fill this out, we'd love to know how many people are attending this webinar today, and thank you very much in advance for doing this. And while you're filling this out, for this first part of the webinar series, I want to let you know that our panelists will each take a few minutes to present information about licensing issues in each of the geographic regions they have worked in outside the U.S. The second part of this webinar will be structured as a Q&A. We'd like to receive questions from those listening in, so if you would like to submit a question during the webinar at any point, during the slides or during the Q&A session, please use the Q&A feature on your toolbar that you'll see either at the bottom or top of your screen. So we're going to start by having our speakers discuss licensing issues in each of their respective regions. And David, could you start us off?
Sure. Thank you, Kirsten. And I'm going to go straight to the first slide. A lot of people have the misconception that when you structure a licensing agreement with any entity in China, that you have to fight for home court advantage. This might seem very intuitive and very natural, even to a lot of my fellow lawyers who are not very familiar with the dealings with Chinese entities. But in fact, this can be very, very tricky, because the next point will show that since there is no reciprocal treatment in terms of recognizing each other's court awards, meaning the court decisions in the U.S. will not be executed, will not be recognized by Chinese courts, and vice versa. And therefore, you really have to make sure that you have something in order to be able to collect any assets against any award. First of all, unless they have significant assets in the U.S., you won't be able to do anything because you go to China, you go to a Chinese court saying that I got this winning victory out of a U.S. court. They will say that, well, we don't recognize that. So you're going to have to rely on whatever assets that they have in the U.S. to collect. So that's the first thing. And the other thing is that home court advantage, of course, could be a huge advantage for Chinese entities. So what do people do when they're caught in this kind of situation? And here, I would highly recommend that you consider arbitration and make your arbitration the final and binding choice. And because each arbitration is treated as a privately negotiated contract, and therefore you don't even need to have a separate kind of a legal recognition for U.S. and Chinese courts, and the arbitration award can be executed against the losing party in China because they're part of the New York Convention, and this is probably a much better way to go. Next one is that often your entities in China would agree to using Hong Kong International Arbitration Center as an arbitration site, or Singapore, or even in Shanghai these days have established a reasonable reputation as a pretty much a fair and respectable arbitration center. So those are typically the ones that they're willing to accept. Of course, you can also try New York, San Francisco, or whatever, but these are typically the arbitration sites closer to their home, and they're more willing to accept. Next.
David, can I actually just interject with a question that's come up here because it's right on subject? Yep. And that is, someone asked, will most Chinese companies agree to the WIPO expedited mediation or arbitration?
That's a possibility. The challenge is that it's not very, very familiar to most of the Chinese entities, especially if they're not very experienced with IP licensing per se. So what I have suggested here, these are more general purpose commercial litigation, or commercial arbitration venues. So more likely to be well recognized and respected. So you can certainly try. Okay.
Great, thank you.
Sure. The next issue is that you need to know that there are certainly some gotchas in the legal structure within China when it comes to licensing technologies into China. The first one is this. Out of the regulations on administration of technology import-export, and this is out of 2011 version, which is still in effect. Article 25 and also the contract law, Article 349, it's similar. They both stipulated that licensor shall guarantee the IP being licensed to work for a specific purpose. You can imagine that for most U.S. institutions, especially universities, this is a very difficult clause to swallow because we typically cannot even predict if the technology will actually work. We know the technology is being outlined in the patent application or in the granted patent, but we don't know the actual commercial application. We don't know if it's really going to work in the licensee's environment. But here it says that we shall guarantee that it works for specific purpose. So the way to deal with it is perhaps to show that you have literally negotiated on this particular scenario, and you have agreed to a particular damage kind of a containment measurement. For instance, if it doesn't work at all, fine. The worst case scenario will refund you partially or even in full the licensing fees. But under no circumstances should you allow your financial bottom line to be exposed, meaning you cannot possibly pay for other unforeseeable consequential damages and loss of customers and whatever. So you need to be very careful. This is the first gotcha. The second one is that licensor shall guarantee the IP ownership and that the licensor has a right to license that technology. This may not seem like a big deal, but as the famous case now, Stanford versus Roche, will demonstrate, sometimes, especially in the university environment, in the last minute, you might have a previously unknown co-inventor coming up saying that I got a share of that too. So the exact 100% waterproof IP ownership, usually you don't want to really guarantee it, but since the law, actually the regulation in China actually requires that you do, again, it is something that you could actually stipulate in the contract saying that the maximum damage you're willing to give up, you're willing to give the other party is capped at a certain level. Fortunately, this is after this year's major revisions of the import-export regime. We no longer need to guarantee that our IP, licensed IP, will not infringe any third-party rights. This is now no longer an issue. And also, in terms of how we arrange the future enhancements, it's now completely left to the two parties to negotiate. But still, the remaining two big issues I have outlined here, and hopefully people will pay some attention to it, especially for lawyers not particularly experienced in dealing with licensing technologies to China. You really need to pay attention to that. Next slide.
Actually, David, really quickly, we had one other question on those on the guarantees, and that was whether those could be handled through an option before a license. Have you seen that happen?
Sure. The Chinese entities are not as familiar with the structure of an option. So depending on the sophistication level, you can sometimes I even have to say, look, an option is just a very short-term contract. Here you have a contract that's only 6 months, okay? And it doesn't have too many terms. You can go play with the technology and come back and decide what you want to do. But certainly you can do that. And in that case, you can also limit your liability because you are not really licensing the technology, not yet, during the option period. That's a very good point.
And I have two other questions from someone, from two different people. So how does this work with these guarantees and the sovereign immunity of state universities? Have you seen those conflicts? You're laughing, okay.
Yeah, well, sovereign immunity has been a controversial issue even in the U.S. And certainly if you're in the U.S. as a U.S. entity, being sued by another U.S. entity, I think that you may have certain protection. But in the international context, I'm not certainly not an expert in this arena, so I will not be able to give you very good advice. But my suspicion is that you need to be very careful because in the international context, I'm not sure the state sovereign immunity can offer you quite the same kind of protection that you would within the U.S. Yeah.
Okay, and then I have one last question before moving on to the next slide. Is that someone said they had done licenses in China and they didn't have these guarantees in them. Does that mean the regulations would override what was actually said in the license agreement, or how does that work?
Yeah, the reason why those gotchas are so significant is because they are what you call invisible terms. So the legal regime is set up in such that they don't really care if you have, even if you have negotiated otherwise. They're saying that, well, our legal requirement will trump your private negotiation terms. So if your license contract is silent on those, yes, those specific clauses will be treated as having been negotiated and having been included in every single contract involving import of technologies from outside. So technically speaking, yes. Unfortunately, you have to regard those terms as part of your contract, even though you had no intention to do it like that. But the good news is that all of these terms are heavily controversial and debated over the last few years. And this is exactly why this year we're seeing so many changes. And so far, those two big ones still remain. But rest assured that when it comes to real issue and real dispute resolution, you probably will get some leeway especially if you ask the U.S. government to help you out. All of these issues have been on the agenda between the U.S. and China in terms of a trade negotiation.
Okay, thanks.
Sure. So the last slide I have is, do you really want to audit them in China? So the question is, typically in our licensing terms, we have royalty rates, and then we have all kinds of milestone payments and all kinds of measurements that we rely on our licensees to be honest and to respectfully report the actual numbers. So let's take a look at some of the issues. So the problem is which set of books do you want to see? In China, just like in a lot of other developing countries, they have one set of books that they want to show to their investors, one set of books they want to show to the tax auditors, and maybe one other set of books to certain major shareholders, what have you. So the concept of one consistent set of accounting books, even that is sometimes challenging. So you may not really get the same kind of treatment that you would if you go audit them. Next. Even if you could get a superficial agreement that you want to exercise your contractual right to audit them, and by the time your auditors come on site, there are all kinds of ways to slow them down, to really obstruct the process. And we have heard such things. And also when you complain to the local law enforcement, and oftentimes these entities that you're dealing with may be major tax-paying entities in the local scene. So they, in fact, could be very protectionistic in terms of dealing with you as an outside foreign auditor coming in. And therefore, next. The suggestion is very simple: try to avoid the need. So instead, rely more on fixed annual royalty payments. Sometimes I would say that, well, let's talk about your financial forecast, your projection, and let's take a look at them. And how about this? First year, it's this amount of licensing fees. Second year, it's that amount of fixed licensing fees in a stepwise function. But I don't even want to see your books. I don't care about your actual sales. So the assumption being that if their actual sales are significantly different from the assumption, they will have to come back and renegotiate, which we're open to. So next. Success milestone fees, certainly, especially if those are milestones, can be easily observed and verified from the outside. And in other words, if it's an export-oriented company in China, because of the fact they have to go through the export and the customs and stuff, it's often easier to audit. So that's another way to say that if that's the case, then perhaps you could still structure more of the royalty payments based on the actual exported sales. Next. Yeah, I already said that. Next. I think that's it.
Great. Thank you so much, David, for that
Sure.
kind of intro to some of the issues to do with licensing to startups in China. We're going to move around the globe now to the UK. And Terry, why don't you start us off with some thoughts and suggestions on best practices in the UK, licensing to startups in the UK?
Well, sure. And I just want to start by saying there are a lot of similarities between UK and US license agreements, and I think in part because of early affiliation with bottom leaders like Lita Nelson, establishment of Praxis, which is a continuing education and best practices group in the UK, and also the MIT Cambridge Technology Transfer Exchange. So you'll see a lot of similarities. However, there are some nuances regarding joint ownership of intellectual property and a few language differences to note. And the one thing to just keep in mind in all of this is, just as you would in any license negotiation, even within the US, is to pay attention to what people are saying and verify what it means. Next slide. So when you're thinking about some nuances or differences, one of the things is governance and structure. With UK companies who will be your licensee, there'll be most likely a limited company, limited by shares. So you'll see instead of corporation or Inc., you'll see LTD. And this is a limited company, limited by shares. Of course, you want to pay attention to the exchange rates and how they're going to be calculated in your license agreements. The accounting for doing audits or calculating royalties or so forth, it's going to be very similar to the U.S., but it's going to be a different group of words. When it comes to equity, if you're taking equity as a consideration in your license, you're going to be dealing with ordinary shares, which are common shares, and you'll more likely to see common shares than preferred shares often in these agreements, but that changes as we do more and more business together. And ordinary shares like common shares in the U.S., these are shares that involve rights, voting, and so forth. But again, when it comes right down to it, when you are taking equity as a consideration in your license, look at the investment agreement or subscription and shareholders agreement in the UK and look specifically at what rights you have. It's the same thing you would do in any other circumstances. Just an interesting part of the environment and the ecosystem is that you see a lot of government support for new ventures in the UK more than you might in the US. They don't have an SBIR program, but many of the new venture funds and startup venture funds that were started in the UK and got the ball rolling were started by the government. You also, like the US, in your tech transfer ecosystem, you really are working depending on the specific university and the region. But if there's a general observation is that the UK is a lot less litigious when it comes to managing their intellectual property and their contracts. So next slide. Just very briefly, this is just a quick comparison of some of the language differences just in accounting. When we're talking about revenues there at the bottom, we're talking about turnover. When a company is in business, we're saying that they are trading, so you may hear that term. Sometimes you'll hear profit referred to as surplus and so forth. Next slide. Also, again, when you're looking at your equity documents, if you're taking equity in consideration for the license or one of the considerations for your license, they're very, very similar at the end of the day, but your book, your equity book, your details covering your rights for your equity are included in a set of documents that are slightly different. And again, like you would in any transaction, don't just take for granted what your rights are. Make sure that what you're expecting and that you have articulated in your license agreement is also clearly articulated in your investment agreement, subscription and shareholders agreement, and consistent with the Articles of Association with that UK company. Next slide. And so again, in your license negotiations, don't take meetings for granted. And you should never take meetings or what people say for granted when you're negotiating in any country, including the U.S. with another U.S. firm. Always state it back, verify it. Just a couple of examples. One of the things that surprised me when I was just preparing an agenda for a board meeting when I was in England is that my chairman's we were going through what were the priority items to discuss at the board meeting, and he kept saying, let's table that. Let's table that. And I was really getting upset because I thought he was putting everything on the back table, but to table something means to put it forward and discuss it. And so just, nuances like that. You also hear about everybody acting at the coal face, which means to us in the trenches, really, doing the nitty gritty, not looking at things from a high leadership level, but looking at them at the level where people are doing business. And again, and then the word keen, if somebody could say that's a very keen royalty rate, you might think it's a great royalty rate, but sometimes keen can mean something that's the lowest budget possible. So again, just don't take meetings for granted. There's all sorts of other English words that mean one thing in the U.S. and the U.K. that are fodder for great fun. And my last name, Willie, alone was the cause for a lot of comic relief in my organization. So next. And just to wrap up my slides, there are a number of really excellent resources if you are going to be negotiating a license agreement with a company in the UK. And one is Praxis, which ASTP and Autumn have all worked together on best practices, basics of licensing, and so forth. They often use the Lambert agreements or the Lambert toolkits, which are template agreements that have evolved over time with the help of academic institutions and industry, and are excellent guidelines, especially regarding joint ownership of intellectual property, because there are some important differences there. And then the European IPR help desk is very good when you want to better understand some of the IPR rights or intellectual property rights. In the UK of Europe, they also have a guidance on issues to take into consideration because of Brexit. And then finally, Companies House is an excellent resource. So if you want to do some due diligence on the company that you're going to be licensing to, this is the organization where you can get in online, look at an overview, look at their filing history, how long have they been in business, or as they say, how long have they been trading. You can see if they've been filing their annual accounts appropriately. Companies are required to file annual standard accounting documents and documents that show how they're doing from a business perspective. It'll have a list of people who are officers in the company and any charges which are liens on the company. So again, an excellent resource. Also for a couple of websites, startup.co.uk is also excellent. Thank you.
Thanks, Terry. We do have one question about if you could go a little bit more into the Lambert agreements and Joint P with regards to foreign parties and how that works, but also maybe just in general on the Lambert agreements, what types of agreements are a part of that?
Sure. I'm just having a coughing fit. I apologize. The Lambert agreements are primarily for collaborative research. But again, they have, so when you're in situations where you're going to be developing new intellectual property together, so if you are into a license arrangement with the company where that company may be continuing to do business with your university, that's something to look at. There's a lot of information online, template agreements and so forth.
And do they address working with non-UK, and like, are they mainly just for UK entities working together, or with a non-UK and a UK entity?
Primarily, if it's non-UK, it's European, but they do go into some detail about what you would need to understand about intellectual property rights there if you were to joint invent. And it's that in the UK and in some European countries, if you are a joint owner of IP, in the US, if you're a joint owner, and you have two joint owners that are US joint owners, two US SMEs, you both have all rights as an owner, except as otherwise dictated through legally binding contracts. But in the UK, you don't have, both parties don't have all rights, or all SMEs don't have all the same rights. SMEs that are entities that can produce the product have more rights than perhaps a university would. So it's more important than usual when you're negotiating those types of terms to take that into consideration. In the U.S., again, when you're dealing with two U.S. SMEs, you always have the fallback of saying, well, even if I, don't license this, I'm still going to have freedom to operate or freedom to do whatever I want with it, including licensing my rights to a third party to commercialize, where in the UK, you don't necessarily have those license rights.
All right, thanks. That's really helpful. I may have some people follow up with you on those because I think it's a pretty interesting situation, what they did there with the Lambert agreements, which made a lot of sense because of the rights and how they can be used by the multiple owners in Europe versus how it works actually in the U.S.
Yeah, and again, I went back to revisit the Lambert agreements in preparation for this, but I did not dig in deep enough to know whether or not they dealt with the countries we're hearing about today.
Okay, great. Yeah. All right, thanks. All right, well, thank you so much, Terry. And now, Amir, moving on to you and working with startups out of Israel.
Thank you very much. So can I get my first slide, please? Thanks. So many of the things I'll talk about today relate to the different structures of tech transfer organizations. So in Israel, as you can see, all tech transfer organizations are actually for-profit companies, which means they are able to work a little bit differently than here in the US, where most of us are a department within a university. And actually in UCLA, we have a hybrid model, whereas although we are all UCLA employees, we report to an external 501c3 board, they drive us to become more commercially oriented. Next slide. So if you think about the structure for a typical startup company in Israel, one of the most striking differences is the equity holding. So in Israel, a tech transfer company is willing and able to hold significant percentages in those companies, well above, sometimes well above 20%. There are no, because they are all private entities, there are no concerns about tax-exempt bonds or dual uses. Which also means that the faculty members usually are not holding their own equity in the company as founders. Their share will be held by the university, by the tech transfer company, until they can be sold in the markets. The agreements typically will be, in a way, more complicated than what we see here, because they bundle a whole host of rights in a single agreement. So you will find a research and license agreement in the same agreement. We used to bundle know-how and software together with patents, no problems, and therefore driving more certainty and engaging more collaboratively between the startup companies and the labs. On the other hand, the volume or size really does matter. And so while in Israel, you can expect the tech transfer office to be highly involved in the daily activities of the startup company, they will send representatives to boards. We'll review every sublicense agreement given by the startup company. As you know here, we seldom appoint people to boards or as observer to board, as an observer in board seats, and we'll seldom actually do a deep dive into a sublicense agreement to see if it is in compliance with the main license agreement. Next slide. The general concept in conflict of interest in Israel will be avoiding conflict of interest rather than managing it. So you will find a very high ethical wall between what the activities that faculty can or cannot do under their capacity as inventors, actually trying to shield them from the brutal world of doing business. Unlike the conflict of interest arrangement you can find in the US, the notion is that tech transfer company is the shield and perhaps even the sword of negotiating the business terms with the startup companies, the investors, and the advisors. Many universities will have embedded VCs in them. So in addition to the traditional tools of bridging the gap as project within the university, they have sidecar funds that will help these startup companies during the stage fundraising or even into the round A, which makes a huge difference on the availability of funds, but also on the university potential upside from equity. Both parties in Israel will be typically represented by outside counsel, typically by high-paid partner in those firms. So transaction costs will likely to be higher, and the deal structure can get very complicated. As far as negotiation style, you can expect negotiators to be very direct and tell you exactly what they want to achieve. Some people like that style, some don't, but just be ready for a very direct negotiation. People won't tell you that they are keen about their royalty rates, and simply tell you that they don't like them. Many companies are being sponsored by the Israeli government in very favorable rates. So some of the startup companies can enjoy up to 85% of their budget from the Israeli government, whereas the private sector will contribute only 15%. But that will lead to a whole series of other questions that you need to consider when licensing into Israel. Next slide, please. So the governmental support comes with strings attached. Very similar to the federal funding, you have to give preference to manufacturing in Israel. And so if your projects, your patents were funded by the federal government, there may be a conflict there. If you want to export, so if the company that wants to expand its reach and open offices and actually export IP outside of Israel, there are financial fines to be paid to the government. And lastly, the IP ownership structure may contradict IP policy or patent policies in our universities here. So when you give a license to an Israeli startup company and then they tell you it's being funded in part by the Israeli government, you have to think about all these limitations and see if they work for you. And I think that's my last slide. Thank you.
Terrific. Thank you so much, Amir. Actually, can I start off with asking a question to you, Amir, then about the startups, when the U.S. universities are negotiating with these startups, potentially that are starting in Israel, and I'm going to ask the same question to Terry and David about the regions that they've worked in. Are they usually represented by a CEO, an investor, an attorney, another kind of stakeholder in the company? And how likely is it that that person has worked with a U.S. university before? In other words, what kind of education are the U.S. universities perhaps going to need to do in that process of negotiation?
So I think most of Israeli entrepreneurs will typically take a license from an Israeli company. So there'll be a learning curve to understand the subtleties and the in and outs of U.S. university policies. They'll always have a lawyer working with them typically. But I think what you'll find most surprising is that, we may sign a term sheet with a CEO and his lawyer, but then you'll often find when the investors come in that they will do another round of improvement. So until the final agreement is not signed, even a term sheet may end up being just the beginning of a next round of negotiation.
Interesting. Okay. Well, I think that's good for people to know, since sometimes I feel like, okay, we've gotten that part over with, but it may not really be over with yet, that there may be another round of that depending on who comes in to invest in the company then.
Yes, absolutely.
Okay, great. So Terry, same question to you about who usually is representing the company and the likelihood, if they're working with a U.S. university on this license, how likely they've worked with a U.S. university before, and understand perhaps some of the differences and nuances there.
It's usually a CEO, and it's usually, likewise, it's a CEO. They usually have good counsel, but it can be somebody who's a first-time CEO. It may be somebody who's very experienced and has done licenses before. It can be the whole gamut, depending on the age, maturity, and sophistication of the company. And so it's very likely that the scientific founders of the company have worked in the U.S. at some point, either in a research collaboration with other U.S. scientists or as a scientific advisor to a U.S. company. So there tends to be that level of sophistication there. And like any license agreement, I think we always have to assume that it's going to get amended somewhere along the line, whether it's because investors come in and see some liabilities they think they need to mitigate, or that needs to be clarification, or the business has evolved enough where the terms may not quite fit anymore. But it can vary.
Yeah. All right. Which may be the response we're going to get everywhere, and you're always going to have to, deal with the situation that arises on this. But David, I would love to ask you the exact same questions then for these startup companies perhaps coming out of China and licensing IP in from these U.S. universities.
Sure. For Chinese startups, typically, again, you'll be talking to the CEO directly, or very likely it will be somebody, maybe a chief scientist with a U.S. degree, advanced degree, who's somewhat familiar with the structure and the procedure. But still more likely than not, they haven't really done a deal like this before, and you're likely to encounter all the same problems that my fellow co-panelists have already alluded to. And in addition, one thing to point out is that in China, the overall experience dealing with university licensing, even domestically speaking, is still at the nascent stage. So there's not a whole lot of sophisticated help they can get, even from their lawyers. And therefore, you're likely to have to explain a lot of concepts, making someone like me sometimes very uncomfortable because I feel like I can't be negotiating on your behalf, but I have to explain some of the concepts. So it's a very strange situation sometimes.
I can chime in on that because in my previous role in YEDA, we signed 2 licenses with Chinese entities, and the educational process of what it takes to license a patent or technology from a university was a very long process that we had to use a local consultant to do that. But then it really became dicey once the agreement was actually signed, and the Chinese company actually expected to get from us a working and functioning solution, and we told them, no, now you have to start your R&D. So even after all that process, there was still a very significant gap on what they expected to receive from us.
Yeah.
So David, we have a couple of other questions on doing these licenses with these Chinese startups. One of them is, do you have any advice on taxation on payments from China and how to work with that through these perhaps these royalty payments or other payments that you're receiving through the licenses?
Yeah, they're not different from any other licensee. You always get some pushback saying that, we want the tax to be carved out. We need to negotiate that. Try to resist that. It's complicated enough. You have to deal with your own tax situation, not to mention that a lot of universities here in the U.S. are really nonprofits, very, very different in terms of structure and obligations in terms of tax liabilities. And in China, the tax system is awfully complicated, and there are all kinds of incentives in terms of they're getting some benefits because they're classified as a high-tech entity, and if they actually get any externally introduced, meaning foreign technologies, they sometimes get additional incentives. And there are central government incentives, there are local government incentives. It's really not something I want to be dealing with. So my advice is to stay out of it, saying that your tax issues, that's your tax issues. Don't drag us into it.
Great, and I'll have another question for you in a second, David, but I'd like to jump back up to another question that one of our audience members had actually for you, Amir, and that was regarding the exclusive KnowHow grant. Is this limited to software copyright licenses only, if you're allowing us an exclusive KnowHow grant?
So I guess the question is about Israel, not the U.S. In the U.S., we're doing KnowHow and actually also software on a non-exclusive basis. Just because the legal infrastructure to support the university ownership and the fact finding behind it is not 100% clear. But in Israel, yeah, we used to give exclusivity to KnowHow as well. I mean, we used to have an annex with a fairly detailed explanation of what is given, and we used to grant exclusivity to that KnowHow for a specific company to develop our product, which in turn allow us to get a significant royalty tail because of that exclusivity. I mean, royalty tail after patent expiry.
Right, yeah. That's interesting, definitely, because it does seem to be certainly different than the U.S. practice overall. Another question that we have from the audience is about CFIUS. David, so we had done a webinar on CFIUS earlier this year with some attorneys from Wilson Sonsini. I'm curious about your perspective and knowledge on this, about how CFIUS is affecting Chinese startups and actually licensing now to Chinese startups, considering potentially these restrictions that are being put on these particular technology areas.
Yeah, that's a very new and evolving situation. In general, CFIUS has the process in terms of investment control. And as the trade war between China and the U.S. begins to take on the real form of a war, as opposed to kind of civilized negotiation, I think very few people could really give you the crystal ball version of future prediction. It's the best way to say is that you need to proceed with a lot of caution. It's likely that you're going to have additional government regulatory oversight at the minimum, and sometimes there may even be last minute and totally unfair blockage. Certainly, some of the proposed investments by Chinese entities in the U.S. have been blocked, in my view, sometimes quite fairly, sometimes really a little bit in a very highly paranoid and not all the straight up and up manner. Certainly the other direction, we have similar examples. So the most recent kind of a boiling point is the Trump administration, actually not the administration, I should say, but Mr. Trump himself. He texted about 10 days ago, I think, that he might consider not allowing Chinese companies to be listed on any U.S. stock exchanges. And as we know, some of the largest Chinese tech companies are public entities on both NASDAQ and on New York Stock Exchange. This has caused a major disruption of the market immediately following that comment. So some of the companies lost as much as 5 or 6% of the value in just one day. It recovered a little bit only because the administration actually then clarified that at least at the working level, there has been no plans to do such a thing. But you can imagine, so we're talking about not just CFIUS, but just overall, the whole atmosphere is almost toxic at this point. So I don't think, I'm really qualified to say anything smart, intelligent, that will be safe enough. This is a really a highly volatile situation. And also, let me point out that in terms of investment in some areas, on both sides, the two governments have regarded some of the data to be super sensitive. So, for example, in the case of China, there are some genomics data that they will consider to be not being able to be exported outside of China, no matter how much you actually removed all the identification tags. And similarly, in the U.S., we're seeing more and more of a cautious approach to a lot of data sharing. So even a pure big data company, you need to really proceed with caution these days. That's an unfortunate situation that we're seeing.
Yeah, it sounds like abundance of caution is the right way to proceed on lots of things. But I definitely think there's been that we've seen too concern on mixing investments from both sides, just with not knowing what is coming down the road. There are a few more questions for you, David, that we've gotten from our audience. One is, how common is it for Chinese universities to assign rights in the first place as opposed to licensing the rights? And then if you do license to a Chinese startup company, potentially would they want to be able to assign rights in a sublicense as opposed to actually granting a sublicense as we know it? Have you comments on both of those?
Yeah, it's very common that they often insist in getting assigned rights, meaning getting the ownership right and not just a licensing right. And this has its justification in their own structure, because in their more or less a simplistic structure, a lot of government subsidies or incentives are tied to the ownership of intellectual property as opposed to license rights. So sometimes they literally will tell you that unless we own it, we cannot really get our government subsidy. And to those people, I have often say, let's figure out some other creative solution. I have even a bundle, several different patents. Some are really what they wanted, which I insisted in exclusive license. Some are just nice to have, but not totally essential. And those are the ones we consider not to be our crown jewel, and not the best patents. But we bundle together, so the lesser value ones I can actually assign to them. And the good thing about the government kind of a regulation like that is that they really have no way of assessing the value of every single patent. So to them, as long as they get some patents assigned, they're happy, fine. So to me, I get to keep the exclusive license nature of the most important IP assets, and I'm happy. Now, the next question is sub-licensing rights. I would be a little bit cautious about that because, again, they are typically not that sophisticated in China in terms of the overall licensing structure and how to control all the different things, and even including how to insist on milestone requirements. So in the worst case, you can at least terminate a license or sub-license. So all of those things, I would not feel very comfortable allowing a licensee to willy-nilly go out there and create their own sub-licenses. So I typically would not want to relinquish that control. I would say that if you have a sub-licensee, a potential sub-licensee, let's sit down and discuss it, whether we will allow you to be a licensee negotiating the sub-license, or we would require that the sub-licensee come to us directly. It depends.
Okay, thanks. So we have another question for you, David, about whether there are any mandates by the Chinese government that the U.S. university license must be reviewed by the Chinese government and the Chinese licensee banks before the Chinese licensee can pay fees, patent costs, and royalties to its university licensor. Does that ring a bell with you?
Yeah. How to get the money out of China is sometimes a very, very lengthy process because of strict export control of money leaving China. It's not an open economy. So in order for them to get U.S. currency or any foreign currency and to be able to wire the money, they have to actually go through the local government review, making sure that the contract says exactly what it says and that they're proposing to wire the exact amount of money as stipulated in the contract. And then they need to go to the bank. The bank would need to essentially do the same review all over again. Otherwise, every single person in the process will be held accountable. So you can imagine that sometimes you could be ridiculously held up by a very low-level bank clerk because the clerk has some, misconception about the nature of a particular clause and or a different interpretation of a clause. And then it takes a long time to actually get things sorted out. So it is sometimes very frustrating. But in the end, if you structure the licensing clauses very clearly and very cleanly, do not leave too much to any kind of interpretation, you should be in reasonable shape.
Okay, and is that review you mentioned, is that a one-time review, or is it each time a payment is due?
Each time, unfortunately, yeah.
Wow, okay. That's great for people to know. One last question from your audience, and I'm going to move on to a final question from for each of you. How common is it in corporate-sponsored research agreement with a Chinese research institution to promise IP assignment of what is created with the funding?
They will almost always try to do that, but I think I have been successful holding the line and explaining that you just cannot give away baby until it's born. You don't even know what it is yet, and most of the time they're willing to listen And especially if you can actually compromise a little bit and say that, how about giving you some several month option to consider negotiating a license, and after the IP has been created. So that usually will make it a little bit more amenable.
Great. Yeah. Well, it sounds like negotiation across all of these situations. So final question to each one of you. Terry, let's start with you. What is the best advice you can give to someone negotiating an IP license with a startup from the UK? Is there something in particular which has really helped that go along smoothly? What advice would you advise?
The advice would be similar to when you're licensing to a startup in the U.S. If it's a spin out from an academic institution, I would talk to your counterpart there, and I would check Companies House as you would here in the U.S. to make sure the company is in good standing, because at the end of the day, you only want to license to an organization that's suited to commercialize your technology. So just as you would in the U.S., use your network of business people, investors, and so forth to do proper due diligence on your prospective licensee.
Great. Thanks, Terry. Amir? In Israel, Amir, what would you say is the best advice you could give for someone to negotiating a license with a startup out of Israel?
Yeah, so just in addition to what Terry just said, I would just add, consider hiring a local law firm. Help with the time zone, help with the language barrier, and there are enough law firms in Israel that can give advice under U.S. law and Israeli law. So that will help a lot in streamlining the negotiation and making it faster and more efficient.
Great. And David, same question for you.
I think very, very similar answers, like Terry's and Amir's. Trying to find reasonable and experienced intermediary help in the form of a law firm or a consulting firm can be very helpful. These days, even though China is still in the very early nascent stage in terms of technology licensing and dealing with foreign technology holders, nevertheless, in major cities, Beijing, Shanghai, and in Shenzhen area, there are now several reasonable consultants or consulting firms that have gradually gained some experience. So that is going to be very helpful. Even though your counterpart may not have engaged any of them, you may actually suggest that they get their own consultant or legal representative, because, like Amir also mentioned, sometimes it's very tiring trying to educate your counterpart about all these terms and negotiation process.
Great. Thank you all so much. Before we wrap up our audience, we would really like to collect your feedback on this webinar. You'll notice a link to a feedback survey in your chat box. That's one of the boxes down at the bottom or top of your screen. Please fill this out. Webinars like this are created because of suggestions that you all make to us. And we also want to know your feedback. Was this helpful? Did it actually meet the goals that you were expecting from this? Are there further follow-ups that we could do on this that could help you out? So please fill this out and let us know. It will take you less than a minute to do so. And we really appreciate all of your suggestions on this. And finally, I'd really like to thank you, Terry, David, and Amir, for being our panelists for today's discussion. It was so fascinating to hear about the similarities, perhaps with what we've seen with U.S. licensing, the similarities between each of the points that you brought up about the startups from the different regions, but also where there were differences in how the practices are being done, particularly with perhaps the structures the licenses need to take and other things that are perhaps government associated with those licenses as well. So thank you so much for joining us today and sharing your experiences with that. For our audience, if you have any additional questions for our speakers, you can reach out to them via email. We are happy to follow up with their potentially their email addresses, and you can see those email addresses on this slide, or you can send us any questions that we can forward on to them as well. So thank you everyone for participating in this webinar, and I hope you enjoy the rest of your day. Goodbye.